This is a AZCourtHelp Legal Talk on Bankruptcy Basics by Michael Gordon of Gordon & Gordon, PLLC in Arizona.
To talk a little bit about why we have bankruptcy, we want to provide an opportunity for people to get a fresh start when they've accumulated too much debt for whatever reason, whether it's medical bills or a failed business or just bad financial decisions or things sometimes that happen outside of our control. That's one purpose of having a bankruptcy code. The other is we want creditors to be treated fairly. So we don't want some creditors to get paid and other creditors not to get paid. And so the bankruptcy code provides a system, a hierarchy where we can make sure that creditors are treated as fairly as possible. We can talk about who are the parties that are involved in a typical bankruptcy case. Ordinarily, the main parties that are involved are going to be the debtor. That's the person that files for bankruptcy. So if you're filing for bankruptcy, you're going to be referred to as the debtor. And a debtor can be an individual, a regular person, or it can be an entity like a corporation or an LLC. So the debtor is the person that owes the money and files for bankruptcy. The other person in the party that's involved is what they call a trustee. And in most consumer bankruptcy cases, so Chapter 7 and Chapter 13, where individuals are involved, the trustee is a party that's appointed by the court, and their responsibility is to look out for the interests of your creditors. And so their obligation is to review all the paperwork that you submit in your bankruptcy, and they want to look at that to see that you're being truthful in what you disclose as far as your assets and income and debts, expenses, things like that. And to the extent in your bankruptcy that there's any money to pay out to your creditors, that's what the trustee does. It's his job to take that money and divide it up fairly among your creditors. And so there's the trustee. Now that it says on the screen there, debtor in possession in a Chapter 11 bankruptcy case, which we're not going to spend a lot of time talking about Chapter 11, but that's generally where a business reorganizes. There's not a trustee. The debtor, the company that files for Chapter 11 functions as a trustee, and they have to file monthly reports and account to the court for what they're doing with the business's money. So that's what they refer to with debtor in possession. But for the cases we're going to talk about today, the trustee we'd be talking about would be a typical Chapter 7 or Chapter 13 trustee who's there to look out for the interests of your creditors. There's also the United States trustee. That's kind of the boss of the regular trustee. The U.S. Trustee's Office is a part of the Justice Department, and they oversee what happens or how the trustees that are what they call panel trustees administer cases. And then creditors committees are in Chapter 11s. They don't really have creditor committees in Chapter 13s or Chapter 7s, but in a Chapter 11 bankruptcy case, creditors form a committee and they have a vote on how things are done in that Chapter 11 case. And then finally, and maybe most importantly, the bankruptcy judge. That's the other party that's primarily involved in your bankruptcy case. The judge is the one who orders a discharge in your case. A discharge is the court order that wipes out the debts you're trying to get rid of. Usually in most Chapter 7 and Chapter 13 cases, most parties don't go in front of the judge. If things go smoothly, you'll never see the judge. All that'll happen just through paperwork, and you typically wouldn't have a hearing that would involve the judge unless there was some complication in your case. And so those are the main parties that are involved in a typical bankruptcy proceeding. As far as what types of bankruptcy are there, well, involuntary bankruptcy is also very rare, and so I won't spend a whole lot of time talking about it, but it's possible if you have multiple creditors and you're not paying your bills, those creditors can actually force you into bankruptcy. You need 3 or more creditors, and the value of the debt combined they have to hold is a few $1,000s, and they can actually go out and file a petition for you and put you into bankruptcy involuntarily. That's very rare. For most cases, you're looking at voluntary bankruptcies, and the most common, the ones that are probably most germane to the people that are going to be watching this chat, would be Chapter 7, what they call a liquidation bankruptcy, and Chapter 13, which is a reorganization bankruptcy. Chapter 7, it is what it says is it's a liquidation. So if you file Chapter 7, one of the advantages of doing a Chapter 7 is it will wipe out most of your debts. There are some debts that aren't dischargeable in a bankruptcy, like student loans, child support, alimony, certain taxes aren't dischargeable, but credit card debt, medical bills, debts owed to utilities, personal loans, those things are all dischargeable ordinarily in a Chapter 7. The upside of a Chapter 7 is you can wipe those debts out. It's also fairly quick. It's about a 4-month process typically from the date you file to the date you get your discharge. The downside of a Chapter 7 is primarily that if you have valuable assets that aren't protected or what they call exempted under the law, you could lose those. And so in a Chapter 7, if you had a diamond bracelet that was worth $10,000 and you file Chapter 7, there's no protection for that diamond bracelet. So in a Chapter 7, they would take your diamond bracelet and they would sell it, and they would use that money to pay your creditors. And so in a Chapter 7, it's very important before you file to make sure you understand what property is exempt and what's not exempt. And that way you can decide or know going in whether you're putting property at risk. So that's a Chapter 7. The alternative to a Chapter 7 for most people is a Chapter 13. And in a Chapter 13, you set up a payment plan where you will make a payment each month to your bankruptcy trustee, and your trustee will take that money and he will use that money to pay your debts. And typically in a Chapter 7 or Chapter 13, it's not going to be a 100% repayment. It'll typically be pennies on the dollar. It might be 10 cents on the dollar. It might be 30 cents on the dollar. But you would propose this plan of reorganization. It has to be approved by the court. Your creditors have an opportunity to object if they don't think they're treated fairly. The upside of doing a Chapter 13 is if you have unprotected assets or non-exempt assets, those are protected in a Chapter 13. You wouldn't have to give those up necessarily. So if you had your diamond bracelet and you couldn't bear to part with it, you'd be able to keep that diamond bracelet in a Chapter 13. The catch is you have to pay your creditors at least as much as they would have received if that diamond bracelet was sold. So if that diamond bracelet was worth $10,000, then your Chapter 13 plan has to pay out at least $10,000 to your creditors. And if it fails to do that, the court won't approve it. And you look at your income and your expenses and figure out what you can afford to pay. And then you would commit to making a monthly payment for a period of 3 years to as long as 5 years. And Chapter 13 is also very helpful if you're behind on your car payment or your mortgage payment and you don't want to lose your car or your house. You can file a Chapter 13. And if you're behind on those payments, you can propose a plan that will cure those arrearages. So if you're behind on those debts, the Chapter 13 can pay those off, and you'll be able to keep those assets, the car and the house, if you're behind on those things, as long as you continue to make those payments. So that's one thing that's attractive to people in Chapter 13 is if they're behind and you don't want to lose your house or your car, Chapter 13 is a way you might be able to keep it. The other types of bankruptcies that are on there, Chapter 9 is very rare for a municipality. Chapter 11 we touched on, that's where a business reorganizes. So it's similar to a Chapter 13, but it's for businesses, and the scope of it is a lot bigger than a Chapter 13. A Chapter 12 is also like a Chapter 13, but it's specialized for farmers and commercial fishermen. Here in Arizona, we don't file a lot of those. I've never filed a Chapter 12 or a Chapter 9, so they're kind of rare as well. The ones we'll focus on today will be the Chapter 7 and Chapter 13. What types of bankruptcy are we talking again about Chapter 7? What goes on in a Chapter 7? Well, you have to file schedules with the court that list everything that you own. So you have to list all your assets. You have to list your debts, any property that you claim an interest in. So to the extent you're owed money from somebody, or if you have the right to sue somebody, those things are assets in your bankruptcy and they have to be listed. As mentioned previously, the court will appoint a trustee to administrate your case and to liquidate any what they call non-exempt property. There is a meeting that everyone has with your trustee. It occurs about 40 to 45 days after your case is filed. And I mentioned before, you usually don't have to go in front of a judge, but you do have to meet with your trustee. But I can tell you a little bit about what happens at this creditor meeting, because like I said, this is usually the only time you have to show up for anything in most bankruptcy cases. And people are usually a little nervous about this and not sure what's going to go on. But at this meeting, which they call a creditors meeting, the trustee would call your name, and you would come up and sit at a table with him if it was in person, and he will check your ID. So he'll verify that it's really you, and he'll have you raise your hand. He'll put you under oath to tell the truth, and then the trustee will ask you a series of questions. He'll ask you, did you list all your debts? Did you list all your assets? Do you expect to inherit any money? Do you have the right to sue anyone? Those types of questions. And then if there's anything specific that he's seen in the petition and schedules that you filed with the court, he'll ask you about that. So for instance, again, if you had a diamond bracelet worth $10,000, when you meet with the trustee, he's going to say, tell me about this diamond bracelet. Can I get a picture of it? Can I see it? Can we take it and get it appraised? Because he's interested in liquidating that asset so that he can administer the proceeds to your creditors. Also, if there are questions he has about your finances, he may ask about that. Typically, we provide the trustee with at least 90 days worth of bank statements, and he may have looked over your bank statements, and he may have questions about certain expenses that were paid shortly before you filed, and so he would ask you questions about those types of things. Your creditors also find out that they get notice about this meeting, and if they want to, your creditors are able to appear at this meeting and ask you questions. That's why it's called a creditors meeting. In practice, that almost never happens. Creditors rarely ever show up to these creditor meetings. Most of your creditors, if they're credit card companies or banks or credit unions, they're not going to bother paying an employee or an attorney to go to your creditors meeting to ask why you're filing for bankruptcy. But occasionally we do get a creditor that'll show up, and the trustee will give them usually 5 minutes maybe to ask you some questions. So that does happen. But typically, yeah, that's the only time you have to go anywhere. That's usually the only meeting or hearing you're going to be a part of in most bankruptcy cases. And that happens roughly 45 days or so after your case gets filed. Creditors get notice of the bankruptcy, and so they have a deadline by which they have to file what they call a proof of claim. If there's going to be any money to pay out to creditors, they have to substantiate how much they're owed. So they provide the court with a proof of claim that shows, okay, this is the basis for the debt, and this is how we calculate how much we're owed. And then the trustee will pay them a percentage of whatever there is to administer out. Typically, it takes about 4 months until you get your discharge. And like I said before, the court will enter that, and you'll get a notice. And that notice also gets mailed out to your creditors stating that all these debts have been discharged. And that's typically the end of the case. Sometimes the case will stay open a little while longer if there's money for the trustee to distribute. But for most people, when you get your discharge, that's kind of the end of your involvement in the case directly. If it remains open, typically it's because the trustee is administering the case and paying out money, but your involvement would typically stop at that point. I'll just touch briefly on Chapter 11s. We talked about before. It's a little different than Chapter 7s and 13s. It's for businesses where they reorganize. They propose a plan of reorganization, which their creditors get a chance to look at. Creditors can object. If a plan's not confirmed by vote, creditors get to vote on it. then creditors can even propose alternative plans of reorganization. Again, probably not too applicable to anyone we're talking with today, but just bear in mind that Chapter 11 is another type of bankruptcy. Chapter 13, I mentioned this before, it's the type of reorganization for individuals. So to be able to do a Chapter 13, you have to show that you have regular income. So if you're unemployed, it's going to be hard to do a Chapter 13 unless you have income from some other source like a pension or Social Security. But if you don't have that regular income, typically you wouldn't be able to show that you can fund a plan. And there are some debt limitations for a Chapter 13. It's just under, I think, $2 million in secured debt and around $500,000 in unsecured debt. So if you have more debt than that, you might not be eligible for a Chapter 13. As I mentioned before, you get to keep your property in Chapter 13. Depending on how much money you make, your plan may have to be longer. If your income is below a certain amount, your plan can go 3 years. If it's more than that, it has to go a full 5 years. And as far as the process there's a meeting with your trustee, a creditor meeting, just like there is in a Chapter 7. And then it typically takes another 2 or 3 months after that to get your plan confirmed. And what that involves is if you're represented by an attorney, your attorney and your bankruptcy trustee communicate, and they work together typically to get what they call a stipulated order that you as the debtor sign and your attorney signs and the trustee signs, and then that gets submitted to the judge. The judge then approves it, and at that point your plan is confirmed. And that just means the court's approved your Chapter 13 plan. And at that point, you just need to keep making those monthly payments each month for as long as your plan goes for. Issues that come up in a Chapter 13, people will sometimes lose their job. Maybe they change jobs, then maybe they move. And so there's some flexibility built in a Chapter 13. You can do amendments to your plan if necessary. So if, for instance, you change jobs and now you're making less money, you could potentially amend your plan so that the money you pay out is less because your income is reduced. And one good thing about that, or what good thing in Chapter 13 is trustees don't often require the reverse of you, meaning that, I mean, if your income increased, a trustee, well, in theory, they could say, hey, you're making more money, you can afford to pay more through your plan. I've almost never seen that. They do have you send your tax returns to the trustee each year, so he does monitor how much you're making. But typically, unless your income increased dramatically, they wouldn't expect you to increase your plan payment. However, the flip side of that is if your income decreased or you had a sudden increase in expenses and you needed to modify your plan, that's something that's possible in a Chapter 13. So that's good to bear in mind, that once you get a confirmed plan, you're not necessarily locked into it. You can modify it based on changed circumstances that might happen in the years that follow the confirmation of the plan. So for the process of filing bankruptcy, there are some things that you're required to do. And one of the things that everyone's required to do if you're in a Chapter 7 or a Chapter 13 is you have to go through credit counseling. And the court you can go on their website, there's a list of approved credit counseling agencies. Most credit counseling agencies will charge you anywhere between $15 to $50 or $60 to do or to provide this credit counseling to you. It's generally done online, although you can do it over the phone, and it takes an hour or so. And that's one of the prerequisites before you file for bankruptcy. They're good for 6 months. So if you do it anytime in the 6 months before you file, it's good. I've had clients who do the counseling and then they don't file for 8 or 9 months and they have to do the counseling again. So just something to be aware of there. But you'd complete that credit counseling, and when you do that, they will send you, or they'll send your attorney, a certificate that says you completed that, and that gets filed with the court. So they have you do that before you file bankruptcy, and then they require that you do a second credit counseling after the case is filed. And so that's another $15 to $50, another hour or so on the internet or over the phone, and a separate certificate that gets issued and has to get filed with the court. So those are a couple things you got to do. It's good information. They talk about budgeting, balancing your budget, managing your debt. Good. Some of it's very intuitive stuff you may know already, but it's not bad to get a refresher. So that's one of the things they'll have you do. The bankruptcy estate. So that's a term you'll hear if you file for bankruptcy. They'll say, okay, this is property of the estate, and what that means is bankruptcy estate. So when you file your bankruptcy case, the bankruptcy code provides that basically everything that you own becomes property of the bankruptcy estate. So like we mentioned before, all your personal property, your real property, to the extent anyone owes you money, stocks, bonds. It even can include things that you inherit up to 6 months after your case is filed. So if you came into an inheritance 6 months after your case is filed, you'd have to tell your trustee, and potentially your trustee could make a claim to at least a portion of that inheritance. And so all those things are property of the bankruptcy estate. And there are, as I mentioned before, and we'll talk about later, there are exemptions that carve out things that you get to keep or that aren't subject to the bankruptcy estate. So there's some exemptions for like your vehicle and equity in your home and your retirement accounts and things like that. But things that aren't exempt are things that potentially your bankruptcy trustee could liquidate in a Chapter 7. It doesn't include your wages after the date of filing. So once your case is filed, that date of filing is very significant because everything kind of starts on that date. And for bankruptcy purposes, they're really only concerned, particularly in Chapter 7, with what you owned on that date. And you could your financial situation could change completely in the weeks that follow that, and they're not going to care. You could have, in theory, I mean, you could win the lottery a week after you filed your bankruptcy petition, and because that lottery ticket, if it was purchased post petition after your case was filed, that's not part of the bankruptcy estate, and they can't touch those proceeds. And so everything really does focus on the day you file. They want to know what you owned, how much money was in your bank, what money was owed to you. And they are also very concerned for the 90 or 120 days leading up to that, because they want to know, were you hiding assets? Did you stash money? Are there unexplained withdrawals or deposits? Those are the kind of things they look at. But it is very much focused on that. So as far as after your case is filed, not nearly as much. Those things don't really have any relevance in a Chapter 7. In a Chapter 13, obviously, it's a little different because you're committing to pay your disposable income for this plan payment, and so they do monitor your wages at least until your plan's confirmed. So if your case is filed and your wages were going to increase shortly after that, they may see that and require that you pay more for your plan payment. As I mentioned before, once your plan's confirmed, though, they really don't monitor that much, and so it would be very exceptional if they made you increase your plan payment based on increased income.